Welcome to the next session on generative AI, ethics and AI use. Today we're going to be talking about AI, particularly generative AI, and ethics, how they fit together both in legal practice and in the law school context. First, we're going to define legal ethics. Then we're going to talk about legal practice and what are rules of professional responsibility related to generative AI. We'll briefly touch on the law school structure with the UW Law Honor Code, as well as any verbiage in the course syllabi, and then we'll wrap it up. But this is really a much larger topic and a quickly evolving one as well. Generative AI creates new content. And because it creates new content that's never existed before, we take it as being new and fresh. But at the same time, it raises ethical issues because all of these large language models were trained on existing content written by humans. So language from the beginning, the oldest training content, to the newest training content may have explicit and implicit bias in it. Whether it's great literature or Reddit or legal cases, all of these things are bundled with a whole set of challenges that are evolving as our norms change as a society. So AI, because of what went into making it, these large language models, you have to question what comes out of them and what the results are, and whether those contain biases that may have existed when the document was written. The documents that were ingested were written, but do not exist at the moment. Secondly, because AI ingests everything without judgment, if it continues to ingest a certain falsehood, it may start to repeat that back as part of the loop, because we expect that some AIs will be ingesting AI-generated content as part of the training process. And so for now, you really have to assume that some things might be falsehoods and not just trust what comes out of these engines. They may be making a hallucination, but they also may be repeating a falsehood that someone stated and that statistically comes up frequently enough that it's been repeated by the engine. Finally, you have to consider your privacy and confidentiality. In particular, you don't want to disclose any private information for fear of identity theft or client confidential information. In general, we're just not sure where the information will go and or how it will be stored. And so just to consider would you publish that information on the internet openly? There are ways of handling these issues, but we're going to get better with this area over time, but we're not yet there, especially with the non-legal AIs. Finally, for everything we're about to talk about, this is as of early 2024. The world is changing, and by late 2029, a mere 5 years away, we expect professional expectations will be completely different. So while now you might need to disclose to your client that you used AI in writing a brief, it may be that in 5 years you will have to disclose to your client that you did not use AI when writing a brief because the norms will have shifted so substantially. So consider that these norms are a shifting field and can keep up with the Bar Association of your state and with their opinions. There are major opinions coming out on a weekly basis, some conflicting, some aligned with each other, and we expect them to settle down over time. What are ethics in legal practice? It's a blend of professional responsibility and perhaps for some lawyers, unrealistic expectations. Lawyers right now who've gotten in trouble for using AI have done so because they either thought or claimed that the AI was going to give them what they needed and they didn't need to do any follow-up research or any additional verification of the output. And that is the key stumbling block. If you understand the technology and you understand its flaws, then you are more likely to be an ethical user of these tools. In all states, 40 states out of 50, and Washington is included, technology competence is required. And so part of being a member of the bar is being competent to use the technologies that are available to you and that will improve your practice, but to know when to use them and when not to. That's why I encourage you to play with AI for non-mission critical things, is so that you will have some competence in understanding when to use AI and when not to use AI in your legal practice. AI has so many places in which it touches ethics, it's hard to cover them all in one session. But I will just say, along with Rule 1.1 on competence, you have Rule 1.4, the duty to communicate to your client. And that's going to include a whole range of things, but one of them is the use of AI, your reliance on AI, maybe how it affects your billing, but you're going to have to communicate your work process more clearly than maybe you had to before in terms of what tools you are using to deal with their matter. Rule 1.5, the reasonableness of fees. People have questioned whether AI is fundamentally going to change the billable hour. And some people have said that we'll be able to charge more per hour because we're being more efficient with our time by using AI. And therefore, it'll just all get bundled in and we'll just be more efficient in dealing with twice as much stuff in half the time. Other people have said that they're concerned about AI because it's going to cut into their billings, because if they're more efficient, then they might not be able to bill as many hours per year. But we're going to have to look at what is a reasonable fee overall with the use or failure to use AI. Disclosing confidentiality, we've discussed several times. The idea that information that you input into a system could be found by someone else will be largely explored through these copyright cases about the ingestion of content by the large language model producers. But we're also going to have to read the terms of agreements, especially in a legal law firm licensing context, to ensure that the duty of confidentiality extends to the product manufacturer and that won't be a way for some other party to learn about the searches or the discussions that you're having with the AI. Candor is important in all contexts, and the duty to supervise is incredibly important for one specific reason, and that is your responsibility as a lawyer includes evaluating the output and the products of your paralegals, of your associates, of those you work with, before you pass them along to the court or to a client. It is your duty to supervise the process, and that extends to AI. So what happened when a lawyer filed a brief relying on cases generated by AI that didn't exist is not that they failed in other ways, but that they failed to supervise the AI as if it were an employee. So this is why I've been stressing so much, never send out a document drafted by AI without verifying and validating it first. Because if you do that, you are violating the duty to supervise. And AI is not a novel concept in this area, because the duty to supervise extends to machines or other tools just as much as it applies to people. Unauthorized practice of law is a large and complicated area, and we're going to have to see where the lines are drawn between bar associations and legal information vendors and startups that are providing quasi-legal services. I don't think anybody knows what unauthorized practice of law will look like in 5 years, but I know that there will be a lot of questions asked about, can a computer do unauthorized practice of law? Or can an accounting firm use AI, legal AI products, and therefore be conducting unauthorized practice of law? So stay tuned for that. But in the context of the classroom, the UW Honor Code talks about academic misconduct. And it says that basically cheating, which includes but is not limited to using, and there are several sections removed to focus on this point, are using online sources such as solution manuals or artificial intelligence interfaces without permission of the instructor to complete assignments. So I strongly suggest that you read the syllabus and determine how your professor feels about the use of AI before using it in the course. Or, if it's not mentioned in the syllabus, consulting the instructor before assuming that it's acceptable to use it. In addition, if you are going to use AI-generated content in a submission of any sort, remember that it would be considered plagiarism if it's submitted without attribution. So, disclosure combined with reading the syllabus is the best way to make sure that your use of AI is acceptable within the classroom context. And with that, thank you very much for attending these sessions and listening to them. And if you have any questions, please let me know by contacting the library. All the best and have a great day.